Chairman. Mr. Rubin, you have a copy of the bill in front of you. On
Yes.
page 2, line 8, it says a person may be considered a joint employer only if such person directly, and then goes down to has exercises significant control over the essential terms of employment, including hiring, firing, determining rates of pay and benefits, day-to-day supervision, assigning work schedules, positions and tasks, and administering discipline. As it to be called a joint employer, you would have to do all of those?
Under the language of the bill, you have to do all of those, which
Okay,
is why
so if you do everything, if you hire, fire, determine rates of pay, but you don't assign individual work schedules, you would not be a joint employer under this definition. Is that right?
that is right.
Now, exactly how would your right to negotiate wages as a union work if the person who hires, fires, and determines rates of pay and benefits is not at the table?
You can't. And contrary to Mr. Fassman's testimony, and as the board made clear in Browning-Ferris and later in Miller and Anderson, it's only if the companies that can actually control the essential terms and conditions are at the table that you can have meaningful bargaining.
In Mrs. Kennedy's testimony, she said that the franchisor used to have employee handbooks, a job application form, and helping recruiting employees. Would anybody doing that ever be considered a joint employer?
Well, in the Freshy case, the advice memorandum by the board's general counsel, he made clear that a franchisor would not be liable for making available handbooks and other materials as long as they're optional. The circumstances that Ms. Kennedy described would not, under the board's current view, trigger joint employer liability, which is why of the 800,000 franchisees, none have ever been found in a joint employer relationship.
Mrs. Kennedy, in light of the fact that 800,000 franchisees, none of the franchisors have ever been held joint employment, I'm trying to find out what the problem is that you are articulating. Did lawyers help prepare your testimony and interpret the laws, give you advice on that?
No,
Who prepared your testimony?
I did.
Now, why do you think that, where'd you get the idea that a franchisor might become a joint employer?
We are taking a look at all of the many written articles that are out there in not only the franchise space, but in all business magazines, and trying to understand how our relationship is changing right now with our franchisor, and trying to determine where we're going to head as a partnership with
And are
them.
lawyers helping you get through that?
No.
Okay, well, I think that most of the lawyers are suggesting, as Mr. Rubin said, that there's 800,000 franchisees, not a single franchisor has ever been declared a joint employer. And so we're trying to find out what the fear is. If they are joint employers, they will be responsible for what they did. If they are controlling the wages, then they would have to be subject to the NLRB. If there, Mr. Rubin, if there is a OSHA violation created by the franchisor, would the franchisor be a joint employer under present law or under the bill?
Under the present law governing OSHA, yes. Under the bill, absolutely not, because under the bill there is no joint employer anymore.
And if there's a if there's a failure to pay overtime directed by the franchisor, under present law, would they be a joint employer for that purpose?
Yes, and there are many examples of that, but under the current bill, they would not be a joint employer because there are no more joint employers who control every single term and condition directly and actually.
And how does the bill return us to the traditional definition of employer?
It doesn't at all. The traditional definition of employer under The FLSA is directly or indirectly suffers a permit. It's a completely different standard, the most worker protective standard ever enacted by this Congress. And under the National Labor Relations Act, the Supreme Court said you return to the common law standard. So if you actually read the Browning-Ferris opinion, you see them extensively quote from the Restatement of Agency, 1933, 1958, which states the legal standard, which the board adhered to, and the test in Browning-Ferris, despite what I'm hearing about prospective and indirect, is very clearly stated in the context of collective bargaining. If they have to be employers within the meaning of the common law, which includes direct and indirect, and if they share or co-determine those matters governing the essential terms and conditions of employment. That is the standard that has always been applied. That goes back to the beginning of the National Labor Relations Act. That is the standard that should continue. And of course, these are fact-based inquiries under any standard.
We're going to have to wind up.
I'll end it there.